can we, good afternoon. We have the application, 1 hour 10 minutes, 25 minutes petitioner for applicant, respondent 1, 25, respondent 4, 20, and a rebuttal, 10. Applicant, it's your application.
My Lord, this is Adrian for the fourth respondent.
Yes.
At some point, the petitioner had indicated that he was dropping a number of grounds in the application. So maybe as we begin, we could be alerted as to whether the same position holds, or if not, whether they are doing a different application altogether. Maybe they can clarify the nature of application that they are about to make.
My Lord, in response to my learned friend's information that is 6, my Lord, the first time we came when we filed this application, my Lord, we were devoid of the evidence that has come on record. That means, my Lord, our application will largely be affected by the proceedings that have taken place, my Lord, to the extent that, my Lord, there are new crowds that will be urged orally in our application so as to be in sync with the proceedings. But that does not mean that we are burdening our application.
So what you're saying is that you're expanding it?
Yes, because ordinarily what would have happened is that perhaps the court would have granted maybe a date to file an application.
There is just no, that time does not exist.
That's why my Lord is expanding.
It's okay, you do your best, we all have the evidence.
Yes, obliged.
Yes, please.
Kirago Aduta for the petitioner. Your Lordship, the application is dated 22nd December 2025.
Application.
And it is supported by an affidavit sworn by the petitioner on the same day. In addition to that, my Lord, various affidavits which have been filed and witnesses appeared before you are in further support of that application.
Application dated
22nd of December 2025, supported by an affidavit by the petitioner of even dates,
yes,
and various other affidavits sworn by the witnesses who appeared before you on behalf of the petitioner or for the petitioner. In addition to that, we'll also rely on the oral evidence that was given before this court. And my Lord would just be to...
Did you have the occasion or the thought of letting the other side know what additional aspects to your petition are, so that they had at least the opportunity to consider it?
I would, in fact, I had asked Mr. Mwongela before we took a break whether there is any aspect of the application we were discussing, and he said that he would still oppose the whole of it. But to my understanding, the application that we brought in December has significantly shrunk, but in the course of the proceedings, we may have added something small, but it is less than 50% of what we had filed. Maybe some few aspects here and there.
Okay.
Yeah. So, in that application, my lord, there are directions which have been issued, which were issued by this court on 15th of January 2026. And the report that came pursuant to that, to those directions,
The DR's report.
the DR's report, that have made various prayers spent or what otherwise substantially complied with. So that as my learned friends come to give the particulars, and my lord, as I said, it will be very much less than what we had filed. We will be focusing on more targeted areas, such as the complete King's lots for all the polling stations. And various strategic material, which my learned friends will elaborate, for targeted polling stations. And all this,
My lord. Adrian for the fourth respondent.
Yes.
So we want to be sure the application that is before the court. So can we then get a confirmation that the application before the court is one dated 22nd December 2025?
I think he said so.
So that application, and there is no other application before court. Or is there any other application before the court?
The way I understood it is it's the application of 22nd December 2025 with reductions and some new areas. That's the way I understood it.
yes, my lord.
Yeah, because when we were last before court, we had identified the grounds that were being abandoned, and the petitioner had dropped the prayers, the third prayer, the fourth prayer, the fifth prayer, the sixth was reported as spent, the seventh was dropped, eighth was dropped.
Just tell me the prayers which were dropped. Just reread them.
The prayers, the first one was about certification, so that one was spent. Then the second one was about the interim orders for preservation,
Yes,
which
spent.
the court granted. Then there is the third one about reopening scrutiny. That one had been dropped. Then the fourth one, which was to give unfettered and supervised access, was also indicated as dropped.
Was the third one dropped?
Pardon, my lord?
The third prayer was dropped.
Yes, the third prayer, as per the record that I'm referring to, was dropped, as well as the fourth one.
I'm sorry, I haven't even had a chance to look at
Yeah.
the application.
So I marked them, actually marked with the next, the ones that were dropping.
Okay, go ahead.
Yeah,
it's
so the
prayer
fourth,
3,
prayer 3, prayer 4, prayer 5, prayer 6 was indicated as spent. Then prayer 7D was indicated as remaining. So prayer number 8 had been dropped.
so 7A to G except B.
Yes. So it had 7A to G, but the prayer that remained outstanding was 7D. So prayer 8 had been abandoned as per the indication. Prayer 9 was indicated as spent. Prayer 10 was indicated as spent. So that now, if we are to go by this application that it is before the court, the only outstanding relief that will be up for consideration would then be 7D.
Yes,
Your Lordship, I'm not sure I would need to go through all that because it is on record. What we said has already been complied with is prayer number 2 because the materials are in court. We correlated it.
Sorry?
Prayer number 3 was not
You're
dropped.
pursuing prayer 2?
Prayer number 2, we said because the materials are already in court, that one we won't pursue because the materials are secured.
Yes.
Then we went to prayer number 3, and we said that that has not been dropped. What we said is that upon production of evidence, we may minimize the targeted stations or be more focused on certain stations. So it was not dropped. Prayer number 4 was not dropped at all. We may actually, during the hearing, amend that prayer to reduce its application. That's what we said. We said, upon hearing of evidence, we may adjust the scope of the prayers. Prayer number 5 was not dropped, but the evidence which has been given before this court even makes it more critical that prayer number 5 be pursued. Prayer number 6 was not dropped. Same as 7, we may adjust it slightly, but it was not dropped at all. Then prayer number 9, no, prayer number 8 was not dropped. Prayer number 9, that one we agreed we will not even pursue it because there is an affidavit that produced those documents, the list of POs. So prayer number 9, we are not pursuing. Prayer number 10 is at the discretion of the court, but I'm sure that one we can dispose by way of written or of submissions, the final submissions. So we may not need to file any further affidavit. So it is as simple as that. Yeah. So maybe.
So there is a difference in the opinions of the council about what is pending before me. At the time when the application was first made, I know I am the one who insisted that we hear the application prior, so that if there was anything we could dispose of, we dispose of it earlier.
Yes.
And then when it was proposed to me that we subject the application to evidence, it was agreed consensually, I think, that we do subject to evidence.
Yes, my lord.
I don't have the record. I think I would have to look at my book to see whether all these prayers were suspended or dropped, or what the wording was used was. For now, I will hear the prayers that they are going to ask for. Okay, Mr. Kamara?
That's okay. We have no problem even if they decide to seek all the prayers. What we just wanted is clarity, so that we can make it
what
easier
would
for
have been,
everyone.
I should have made an order before we parted. I should have given a direction that the petitioner, applicant, to notify counsel on the other side what is it they are pursuing this afternoon, so that you know what you are answering. So you don't prepare for matters that are irrelevant, which I'm sure now you have had to prepare for. But don't forget, I've also been hearing the case, and the court also has suo motu powers to do certain things that, in the interest of justice. So I will balance the rights of the parties in any event. Mr. Gashuba, you look very unhappy. Although you have a smirk, which is approaching a smile. Are you okay?
I'm okay.
All right.
Just that I wish Mr. Kirago was clearer,
Yeah.
so that we know we are pursuing scrutiny,
Yeah.
because that's the indication you had given.
Is there somebody on that side who has a list? Actually, maybe what I should do is let us retreat again. And then you produce a list of what you're pursuing. So the other side knows that we are pursuing which stations and so on and so forth.
Yes, my lord.
Can we just retreat for another 10 minutes?
Yes, yes.
So that you let them know, because if they have prepared the whole world and then you're only dealing with Nairobi.
My lord, the directions you're giving us, my lord, are in sync with the operation principle, that we do not be seen to be running the skelter and having a picnic expedition. To be precise for us to give him.
I should have given that direction earlier.
Yes, my lord. That's correct.
I apologize. So let's take another short break. The direction is this.
My lord, sorry, before you pen off, it would even be available, as far as we are concerned, for the petitioner just to come and read out an application. They make an application of what they are seeking. Maybe they can extract from this one, so that now we have a clear list of the issues.
Will you be able to do that within
No, we'll make
15
it
minutes?
easy for them to understand the areas we are targeting. We'll make it very easy for them to understand.
Okay, let's make the direction as follows.
Actually, out of the 25 minutes we had, decided to spend only 15 minutes because you don't need to restate the law.
The direction is that the applicant shall write out a clear list of the areas in their application, because we are still referring to this application, that they wish to focus on, and any expanded areas for encounter scrutiny. Is that sufficient?
Yes.
And then serve it on the respondent. Let me tell you why we are struggling with time. Next week on 22nd, from 22nd to 27th, we have an annual leaders conference for the judges, High Court judges. On the week following that, actually, in the middle of that week, we have recess, the Easter recess. So I would not be available. But in any event, any directions with regard to scrutiny and recount have to be done. Actually, I have to spend, I think I'll be here tomorrow, writing out the directions, because they have to be very clear. Otherwise, we end up running helter-skelter and creating more trouble for everybody, because the parties have to be involved in whatever exercise will be done. And that direction has to come out to the parties in good enough time for the parties to engage themselves, because the parties will have to send a rep or two to participate. And then that report, the report of the DR, cannot take that long. I am seeing it having to be done by the 17th of April. by the 17th of April.
That is if the application succeeds.
If the application succeeds, yeah. Well, let me put. let me say one thing, and I think I've already said this. There's one aspect, the strategic materials box will have to be scrutinized. So if nothing else succeeds, that one will. But by 17th, I would like to have a report of whatever it is that the DR is asked to do. And then it has to be out to you so that you can make your observations and comments on it. And then we still have not done submissions. We still have to do submissions. So you can see the time is really tight, and then I have a normal course list from the week, from recess on the 7th. From the 8th, I have a normal course list. And I would not like to upset. I don't mind upsetting this afternoon altogether because I think it was just judgments, wasn't it? It was just judgments. But I can't upset all those other weeks because we had really tried to plan ourselves with sufficient time. It's just I think we were a bit irresponsible, and I was not as active in terms of managing the time as I could have been. I think I let us too loose. So you can see the time struggle I'm having. Yeah, that is why I think we just must finish this. 23rd, put in your diary, 23rd, 24th would be submissions. One of those 2 days. And those are the only 2 days which are available for me for submissions. Yeah. So one of those 2 days we will select. Yeah. Which one is preferable, by the way? 23rd, 24th? Morning hours, 24th. That's a Friday though. 24th is a Friday. 23rd is good. Let's just record 23rd. Time is running. The time is running. So let's be back in how many minutes do we need? Applicants? For you to prepare this piece of paper.
15 minutes.
Will serve.
15 minutes, my lord.
15 minutes?
Yes.
So we can be here at 2:05, 2:10.
Yes. 2:10. Yes.
Let's be back at 2:10.
Very well. Thank you.
Sorry, my lord.
Yes.
On the dates that were being proposed, I was checking my diary.
Yeah.
And they don't seem convenient.
Sorry?
The date doesn't seem convenient.
23rd.
Yes, because there is a retreat scheduled, which I've already.
Was it? I hope it's not the. I remember you told us about your leave arrangements.
Those ones collapsed. We have been here.
So if 23rd, then we'd have to do it with the Friday 24th. I have no other dates.
It starts from 23rd. The engagement is 23rd and 24th. It's a retreat.
Then we'd have to come forward to 22nd.
22nd is fine.
Is 22nd? How does 22nd look? It's packed. Because I imagine you want to give highlights of your submissions.
Yes.
I know you can write your submissions and I can actually rely on them. But I have not come across an election petition so far in my years where the parties did not want to highlight one or two things. If you don't wish to highlight, you can take the position.
Excuse Mr. Kamoto, because Mr. Kashiba, who is a senior, is still present and steering the vessel very well, so that my Lord will remain with the 23rd.
It's my prayer that we have been working together, so you cannot attempt to put us asunder. So I only have an issue with the 2 days, 23rd and 24th. Any other date, I'm open. 21st is fine.
No, 21st is too close to the date of the DR's report. It's too close to the DR's report. Because if anything goes wrong, we need at least 1 day for the DR to rectify issues or to ask for further directions which must be conveyed to the parties.
And there is a weekend, there is an Easter that is coming.
A what?
Easter holiday.
No, well, Easter, we've already passed Easter. Easter ends on 6th.
Okay, perhaps I don't profess that.
No, we are looking at, is that April? Yeah, Easter ends on April 6th, but the recess ends on the 8th.
My lord, perhaps to propose a solution, because we seem to be stuck with the 23rd and 24th, then probably Dr. Kamodo can submit virtually from wherever he'll be. Then that
He says
could
it's an
work.
event that he's attending.
Unfortunately, I mean, in that event, so it will be a bit of a challenge to appear, because it will mean I will not be the other event which
And being a doctor, you know, it could be an international event for which
My lord,
serious fees are available.
it's most likely political, but we understand.
Let's see if my ready on 22nd.
We have a judgment on that day. We have 3 hearings, 5 applications, and 6 mentions.
Unless we do it in the afternoon, in the late afternoon.
Yes, I'm available.
Late afternoon? I know parties don't like late afternoon. I certainly don't. Huh? Yeah, late afternoons are usually a bit tiresome. And if I've had 3 hearings, I'm not feeling happy about it. What does Monday 27th look like? Civil is even worse. Let's take it back to 22nd. I think we may have to move some matters on 22nd. It will have to be 22nd morning. What we will do is the cause list, we'll have to push the cause list after them.
Can we start at 8, my lord?
Yes, we can start at 8. That's a Monday though. It's a Monday. 22nd? Oh, you're talking about 22nd?
Yes.
Ah, okay. Yeah, we can start at 8. Okay, 22nd. Okay, so let's take a 15-minute break for that direction, and then we can resume. Now I might have to look at the application. Yes.
Yes, my lord. I want to confirm that we have not been supplied with any write-ups in the intervening period as you are directed, but for the sake of time, my lord, since this application has been pending for quite some time, and in respect of which parties and filed written submissions, we are ready to proceed either way.
Okay.
We are ready to proceed either way, so we are going to be able to know what it is they seek when they are presenting their case. And my lord, we are ready for that.
My lord, I think Dr. Kamotho has not shared the list, but I can see my handwriting on Dr. Kamotho's table. I already shared what we'll be talking about. He already has it written by my own hand.
Mr. Waduta has just passed the paper now.
Just as you enter.
Yeah, let's proceed. Let's proceed. Let's proceed.
Yeah, Your Lordship, Kiragwa Waduta for the petitioner. And without repeating the purpose for this application, I would just like to mention without reading the legal basis of the scrutiny application in terms from the Constitution, Article 86 and Article 81E. As well as Article 38. The statutory underpinning is to be found at Section 82 of Section 82 of the Elections Act. Then in rules, under Rule 29 and Rule 33 of the elections general regulations, together with other enabling laws. So, my lord, what we are seeking to do is to assist the court, and this is the whole purpose of a scrutiny application, to get a full view of the election that is the subject of the petition. So, and this is an exercise that can be prompted by a party. The court can even prompt it itself. So that after hearing the evidence that was laid before you, my lord, in some instances, you may also wish to get clarity. What came out, Your Lordship, is that from the testimony of evidence of the respondent, and in this case, RW1, you will find that there was use of ungazetted forms, for instance. Ungazetted forms. For instance, a form that was called Kim's validation forms, which you would find also in the report by the Deputy Registrar at page 59. And such forms, in the total in number 701. Basically, people, those are voters, 701. With KIMS validation forms, which are not statutory forms, contrary to Section 22 of the Statutory Instruments Act. So the question of scrutiny or the need to know would even start from there. Who are these people? What are these forms? And these are numbers, my lord, that are capable of overturning the election. The law requires IEBC to keep election materials for a period of 3 years. And therefore, these materials are available for scrutiny. And when we retreated to agree on what we purpose to, or which areas we purpose to look at, my lord, what came out clear, and this can be confirmed from the testimony of the various witnesses who appeared before you, that for this court to get a full view of who voted or who was identified electronically, this court should be seized of all the KIMS logs. They are just like statements, like an account statement or bank statement. We do not need to know the identity of the voters. We only need to know the entries that went through those KIMS logs. And so that then we can know how many people were identified through KIMS, and then we can relate it to the numbers that were declared, tallied, and led to the declaration. We have more specifics. I'm sure my learned friend, George, you'll be picking it from there. Yeah, Mr. Kiroko will give you specifics on the polling stations so that then we reduce the scope of the application, because you have done that, my lord, very significantly.
Your Lordship, I wish to associate myself with the sentiments expressed by my learned colleague, and in particular, wish to draw your attention to what I may call the five-legged table established under Article 81E on what constitutes a free and fair elections. That is to be Article 81E. I'll not need to restate them. And another Article 86, which has what I'll call a four-legged stool. And all these are to be found through the scrutiny of the relevant places that I'm going to highlight shortly. Your Lordship, it is important that as you retire to write your ruling, that you bear in mind the asymmetrical principle that puts IEBC in a special place. They are the only people, or this is the only institution that is the custodian of the information you need to determine whether the four-legged stool and the five-legged table has all the legs they need to stand on, default of which the election has to collapse. Your Lordship, you have sat and listened to oral testimonies of, amongst others, Isaac Muriithi from Siani, Cicere Njagi, Simon Namu and Dan Degwa from Getivore, James Muriithi Jage from Kaungu, Julieta Karigi, Rendia Bura and Aniseta. And when I say Aniseta, seems to have set the pace of the kind of legs that were removed in this election that both the table and the stool collapsed on. We also had the advantage of listening to the evidence of the returning officer, who at one point in time adopted an escapist approach. At one point in time, Judge, he even claimed there are forms he did not even submit against your own orders. He said they were in his office. Most of the witnesses who came here and testified on behalf of IEBC indeed admitted. We had, for instance, Lydia and Jane, who...
Counsel, maybe
Yes.
it will help me.
Yes.
Because I don't want to write a story.
Yes.
It would help me if you just say, in respect of polling station X, witness Y did this. In respect of polling station Y, witness A did this.
Very well.
We ask for scrutiny, we ask for recount, just that.
Very well, my lord. Let me just summarize it. We have the following. We have the following polling stations, my lord. And this, you find it at prayer number 6. My lord, I don't know whether it's easier for me to just refer to the, because they are listed there. Just say, I give the reason. Because these names pronouncing and writing is, will take more time. Yeah, my lord, from the evidence of Aldin Ibrahim this morning, and also the ICT.
It was RW6,
RW6. Just
Francis. RW5. Yeah.
and RW6. Yes, the ICT person. Lord, it was confirmed that from various places of location, it was possible to add voters in voters' registers. And the stations in that prayer are the ones that the petitioner has given evidence voters were added in the run-up to the election. It is therefore imperative that the KIMs, in relation to those polling stations, be availed and checked so that we counter-check with the physical register that we obtained from IEBC. Lord, that will leave the issue hanging, because then it will be necessary, and this one I related to prayer number 3, that then we need to check in the boxes of those polling stations so that we can see the numbers as declared in the forms inside, and also the voting that took place. We need to see the forms, ballot papers in relation to these particular polling stations.
What do you want to do with them?
Because the case is that we have external people who came. For instance, the KIMS may have 400 people. The physical register that we have may have 398 or maybe even 360. Then we need to see in those boxes, in ballot papers, the counterfoils, and all those materials, so that we see whether the additional people actually voted, so that we see whether there's a convergence or the numbers make sense. In relation to prayer number 3, again, we have listed various polling stations. Such as Gitiburi, Karabari, Muchonoke, where witnesses came here and testified about various activities that took place, including violence, combination of 2 polling stations in one for purposes of tallying. So they are at paragraph 3. So that, my Lord, what we have done with prayer number 3, instead of asking for all the ballot boxes across the constituency, we have narrowed them down to the ones listed in that prayer and seeking similar materials under prayer number 6. That's why we said we move from 134 to around 20 or thereabouts.
Yeah, but you've said the stations in prayer 3.
Yes.
Can you just identify what you want done with each of the stations in prayer 3?
Sorry, my Lord?
Can you tell me what you want done in respect of each of those stations there? There are just about, what, 10 of them?
Yeah, those ones in prayer number 3, we are seeking similar, we have similar requests or prayers. We need to conduct a recount. Scrutinize the electoral materials in them, such as the ballot papers and other forms. We'd also like to access the register in the KIMS kit in relation to these polling stations. And finally, the KIMS kit logs in relation to them.
KIMS kit, register and logs for what purpose?
The logs, my Lord, would assist us, just like in prayer number 6, to confirm that how people were identified and whether the ballot papers that will be found in those boxes tally with the people identified through KIMS. Yeah, and this, my Lord, you recall in the evidence of a lady called Lydia and Jane Gitivuri, and also a witness of today in Sianya, I believe, when violence broke out.
Just identify the witnesses. You need your application.
Yeah.
You don't want to go and look for witnesses. Just
Lydia.
tell me witness number so and so. It's very straightforward. Witness number so and so.
Lydia, for the respondent. Lydia Muthoni.
RW3.
And RW4, that is June. Yeah, they confirmed in the polling station.
Sorry. Lydia RW3, Jane Karimi RW4. Is it confirmed?
Yeah, in the respective polling stations, there were chaos where boxes were moved from the polling station to a vehicle and back, providing the seals that secured the ballot boxes. There was also another witness today, RW6, no, 7. Sorry? Paulino. Yes, RW7. Confirmed also he could not provide the seal number or the number on the seal that secured the ballot, the aperture when chaos erupted at his polling station.
Which polling station was that one of the RW7?
It was Kaungu. The others, we have also given now the particulars in the affidavit in respect of each and every of those polling stations. Because of time, I will not go through all of them. A lot of discussion arose regarding the polling station diaries, especially regarding the reporting and recording of events. Asking for polling station diaries for all those polling stations.
Which ones?
The ones in prayer 6 and 3. In the DR report at page 59, at page 59, there are forms called Form 32. At item number 3, my Lord, we'll also be asking for those forms, the 1072 forms. On the ground of unprecedented number of assisted voters and one person assisting several people in those polling stations, in various polling stations. Still in the Deputy Registrar's report, there are 701 KIMS validation forms, which, my Lord, it was considered are not gazetted forms. My Lord would ask that those forms be tabled before the court. And since it is not disclosed from which polling station they relate, they appear to be just a bunch of forms. We should be allowed to conduct a scrutiny of the boxes of the polling stations that they come from. We are not able to say which, but IBC is the custodian of that information. RW1 confirmed that Form 35As of various polling stations looked altered in terms of the numbers of votes gained or earned or attributable to the candidates. And these arose during the hearing. And my lord, I would like to read this list because it is important that these forms be looked at by the court in rendering its decision. And there are quite a number. Can I take you through it?
Yes, Councillor.
My lord, Kune. Kune, yes. Bingori. Makunguru. Mungau. Mathai. Ngiri. Ruagori. Kiamugongo. Kirimari. Actually, I'm just being told an easier way is to refer them in the DR's report because they have numbers, so that I tell you number 145 that way. That will help a lot. We had reached Ruagori.
Yes, I'll add. We finished with the criminal matters. I'll add everyone time. Give me the DR's report. Yes. You're referring me to page?
We had reached at Ruagori.
DR's report page.
It is not from DR. It's the numbers that are here, I think, are from the polling station number. Okay. The pages the numbers that appear here are the page number in the IBC's.
Which document are you referring to?
The IBC has a trial bundle.
Yes.
Which has the Form 35As. So we have picked the page numbers where you find the altered forms.
So which ones are they?
For instance, if we go to page 42, and this one a lot, we had to use we use the page number at the top right.
That would be page 60, 61.
Is it page?
I've got 3 paginations. You can give me any of them.
Yeah.
Just tell me where they are.
What we have the one at the top is 42.
Top center?
Top right.
42 is 61. Yes. That would be
My lord, we use this document. The one that is going with yours is the pagination at the bottom. So, no, at the bottom.
Is it Kune?
Yeah.
Yeah, it's the one I'm on.
Yes.
Kune.
Yours is page?
61,
61.
42, and 51.
Okay.
It has all those numbers.
Maybe, my lord, for purposes of this, because we have relied on this, I don't know whether we can just pick one, the one that we can rely on. For instance, we use 42 at the top.
Okay, fine.
Yeah.
Yes.
42 at the top.
Yes.
So page 42, page 47, 52, 53,
52.
52 and 53, 56, 57, 58, 62, 64.
My lord.
Yeah.
Yes, your guidance, because numbers are being thrown around. We may not be able to know what stations they are. Is it possible that we get the names of the stations rather than numbers? Because at the end, we will not be able to say what 62 was, what 43 was, but you can be able to tell if it is, for instance, Kune polling station. We'll be able to tell it's a polling station. But page number, at some point, we lose each other.
I'm capturing it fairly well, but you may want to say the station. What are you saying about these stations?
These are the forms where with alterations on the numbers. Yes.
Okay.
Yeah. My lord, I had reached at 62. 62, 64, 65, 67, 68, 70,
65?
67, 68.
Sorry, once again, my lord. Because we have a problem, eh? Page 62 doesn't have a Form 35. It reads
Cancel.
Certificate of Elected Member of National Assembly.
What we are doing is we are looking at the top right-hand corner. I think they have a confusion on their part, and I don't want to waste a lot of time.
That is when my colleague was making it simpler for them,
Yeah.
for all of us, if they could say
The station numbers.
Kune, Chianyi.
Why can't you say the page number and the station, polling station?
Yeah, it's okay, my lord. I was just making it easier for the court to write the number. But 68 Mukororia. I hope you had recorded. Dr. Kamotho, we had moved all the way to 65.
With the numbers. But now the station, you know the stations, because you're challenging stations. Make it clear.
And I'm relying on IBC's document. So, 67 Gatakari, 68 Mukororia, 70 Kanyuambora, 74 Kavengero, 84 Kabachi, 88 Itira,
Sorry, after 74 was what?
74 Kavengero, 84 Kabachi, 88 Itira, 90 Karambari, 92 Gangarawan, 93 Gangara 2, 96 Kirie, 98 Kianjogu, 106 St. Michael, 108 Kamavla. Kamaua. 118 Ibutuka. 127, sorry?
118.
118. 118. 118. Then 127 Kingo.
127.
127 Kingo.
Kirigo.
133 Shiangera. 136 Muthanthara. 137 Kogari. 139 Nthigirani. 141 Kiathambu. 145 Guakaithi. 146 Orwanjeru. 147 Gatorori. 148 Ovarire. I'm just about 3 stations. I finished, Mr. Kashufa.
My Lord, with your very kind permission, Gachuba for the 4th respondent. We are dealing with a specific application, my Lord, dated 22nd December 2025.
Yeah.
And Mr. Kiragu Aduta did give us the grounds that I intend to prosecute. That is ground 3, or prayer 3, prayer 4, prayer 6, prayer 8, and 10, my Lord. My Lord, he is reading a number of stations which are not included in prayer 3, prayer 4, prayer 6, prayer 8, prayer 10.
Yeah.
So we are lost.
I think
We
what
have
he said,
another
it's
application.
emanating. What I understood him to say is that it is emanating from the evidence on alterations. So what he has gone and done, he has looked through the whole of this bundle, and every Form 35A, this is what I suspect he has done. Every Form 35A where he sees a dark mark on it, he is identifying it as a station which requires something that he will tell us. So let him go on, you will answer him.
My Lord, is there some indication of the time which each party has, because we are likely to be taken through this entire document today now? With the
Yeah,
discussion
the way we are going.
Yes.
How much more time do you need, Mr.?
Aduta, is
How
only
much more time do you need?
less than 5 because I have 3 stations.
Okay, so in 5 minutes,
5 minutes.
the petitioner's the applicant's application closes, because we are already on minute number 40.
But my Lord, we perhaps sit in, so that we can also have 1 minute or thereabout.
Let's do this. At 20 past, you will sit down. The applicant's application will be concluded. Then the other side can respond. 20 past. Francis, just check the time, please.
Thank you, my lord.
20 past by that clock.
Yeah, thank you. Kiragu Aduta, I had read 148 over, or
Yes, you
148, yes. 150 St. Peter's, 154 St. Mary's, and lastly, 156 Usambara.
have 156.
156 Usambara.
Yes, what do you want?
Yeah, about this stations, my lord. We will be asking for the original and counterfoils, counter and carbon copies of the forms 35A.
You seek original of what?
Original and the counter they're called carbon copy. Is usually a carbon copy. As well as of form 35A, and also a recount of the ballots or of the votes in those stations, and the KIMS logs in respect of them. From me, I put a comma there. Maybe my learned friend, Mr. Ndego, and come out.
My Lord,
And they came out.
the application for scrutiny and recount, my Lord, is so specific to those particular polling stations. And we are very particular, my Lord, that out of the possible 134 polling stations, my Lord, we've only singled out a possible 32 polling stations or thereabouts. My Lord, this is to safeguard the possibility of falling to the pitfall of being in a fishing expedition. My Lord, we have put up a case that we are so specific as the information that we wish to establish in those particular polling stations. My Lord, in the case of Richard Kalembe Mbeere versus Patrick Mweu, which is number 7 of 2013, the High Court...
Patrick Mo.
Yes, but Patrick Musimba Mweu. The High Court sitting at Machakos indicated that where sufficient evidence of the inter alia alterations and errors in Form 35 had been established to the extent that they affected the results of the elections, my Lord, the High Court had no difficulty in granting the orders of scrutiny and recount of the entire constituency. For us, we are so specific to the polling stations in issue. In that case, my Lord, there were 164 polling stations, and the court ordered the recount of the entire. My Lord, again, in the case of Hassan Abdallah Abeti and Abu Muhammad Abu, the High Court again sitting at Malindi in petition number 9 of 2013, in which the authenticity of the forms, my Lord, used were in issue. Again, the High Court granted the orders of scrutiny of the entire Lamu constituency elections. My Lord, again, this is not what we are asking. We are so specific, my Lord. Again, my Lord, in the case of Daniel Karaba, Dixon Daniel Karaba versus John Ngata Kariuki, again, the High Court sitting in Nairobi, in High Court case number, in High Court petition of 2014, number 5. Again, upon cross-examination, my Lord, the returning officer laid the basis upon which scrutiny and recount of the votes was laid. My Lord, when the respondent, through the RW1, the returning officer, was cross-examined, my Lord, on various aspects surrounding this election, be it the documentation aspect of it, be it the recording of various incidences, and be it, my Lord, the details captioned on the DR's report. My Lord, the answer that came from the returning officer himself was, we cannot know unless we count, unless we check. the person who was manning the elections, my Lord, the individual who returned the fourth respondent as having won the election, was not sure of what he himself returned. He said, unless we check, my Lord. If there is no any other basis, my Lord, that can persuade this court to grant the order of scrutiny as sought, my Lord, the evidence of RW1 persuades you, my Lord, to grant the prayers sought. Finally, my Lord, if you look at form, the 1072 forms, 32, my Lord, witnesses appeared before you, my Lord, and the evidence that came from them was that, my Lord, it was more than one individual assisted voters. And of course, my Lord, without having to allege much more against the fourth respondent, the fact that he never rebutted our evidence, is that, my Lord, there must have been a reason why one individual was assisting more than one or two voters. There must have been a reason. There must have been a conspiracy. That conspiracy, my Lord, cannot be unearthed unless we check the signatures and the names of the persons who purportedly assisted these particular voters. My Lord, and you know, my Lord, if we were to find out that out of the possible 1072, 200 forms were signed or were supported by one assistant, my Lord, that makes a big difference in the total number of the votes, the difference of the number of the votes between the winner and the petition. So it is, my Lord, even for the 701 forms, the validation forms, if you were to go and find out that the validation forms have no legal basis, either in the Election Act or in the rules guiding therein, it will make again a significant difference, noting that the difference between the winner and the petitioner was a mere narrow margin of 462 votes. It will make the entire difference. Again, my Lord, this process will assist you to confirm whether the elections was free, whether it was fair, whether it was secure. And security, my Lord, of the elections does not necessarily mean that there is the absence of violence. That is not the security of the elections we are looking at. We are also looking at the integrity of the materials that were deployed for purpose of that election. For example, in situations where we are indicating that Collins Munene was registered as a voter in Mondu polling station when the registration of voters had closed, doesn't it speak to the integrity of that document, the register? And can there be an election, my Lord, in the absence of a register? And if the register, my Lord, is tainted with legal impropriety, where does the entire election stand on? That's why, my Lord, in the summary of the my summary is that, my Lord, this is the only way, my Lord, you can satisfy yourself whether to admit or grant the petition as freed or to dismiss it. We so urge you, my Lord, to grant the prayer sought, and noting that, my Lord, our application has not been objected to through evidence by the fourth respondent.
Okay. I think your time is up.
I just want to get 1 minute to address that aspect of the fourth respondent.
Which one? You'll get a time to
We
report.
are so much.
Mongela, I'll give you 45 minutes also.
My Lord, Mongela for the first to third. My Lord, the oral submissions which I make are supplemental to our filed submissions dated 10th of February, together with the list and the bundle of authorities thereof. My Lord, in these supplemental oral submissions, I open by stating that, my Lord, the remedy known as scrutiny and the recount is a discretionary remedy. it is not granted as of right. My Lord, the statutory basis for that remedy springs from section 82(1) of the Elections Act 2011, supplemented by Rule 29(2) of the Elections into bracket parliamentary and county elections, close bracket petition rules. My Lord, the sum total of the requirement is there must be laid a basis. The remedy is not granted as of right. This legal requirement, my Lord, was echoed by the Supreme Court in the case of Gatirao Peter Munya versus Dickson Mwenda Kithenji and the two others, 2014 EKLR. My Lord, which emphasized that indiscretion is drawn from the pleadings or from the evidence that has been tendered, or both. In other words, my Lord, the applicant must establish the basis to the satisfaction of the election court. Further, that such remedy, my Lord, is only confined to the stations in which the results are in dispute. My Lord, permit me also to cite to you yet another Supreme Court authority on this matter before I can go to the specifics. The Youth and Advocacy for Africa and the 7 others versus the IMBC and the 17 others, 2022 KESC 42. Again, the Supreme Court emphasizes the threshold which the applicant seeking this remedy must meet as follows. My Lord, number 1, that is scrutiny and the recount must never be permitted to aid the applicant petitioner in the exercise known as fishing expedition. To hand my words to that, my Lord, it must not be used to expand the petitioner's case. The petitioner cannot rely on this exercise known as scrutiny and recount with the hope that, my Lord, what they pick or what they may stumble upon during this exercise is then infused into the pleadings and evidence beyond what they had pleaded and the tendered evidence on. It can never be used to expand the scope of the petitioner's case. The Supreme Court goes on, my Lord, to say where the prayers are general, non-specific, or impracticable in scope and the time, must be declined. Mr. Ndegwa, for the applicant, has cited to you the authority which I also rely upon, Patrick Mweo Musimba versus the IMBC and 2 others, 2022 KESC. Sorry, my Lord, this is not 22. This is petition number E01 of 2022. An application for scrutiny.
The citation what?
This is Patrick Mwemo Simba versus IMBC and 2 others, petition number E001 of 2022. There is no specific citation, my Lord. Okay. Yeah. My Lord, an application seeking scrutiny and recount was dismissed because it was general, it was speculative, it amounted to a fishing expedition, and therefore the claims thereof did not meet the threshold. My Lord, if you look at the application as couched and the evidence that was tendered before you from day one to the close of the hearing, the petitioner applicant does not say with certainty what it is they are going to look into, whether in the materials which are in the election boxes, or what we were told is box 135 containing some strategic materials. They're not telling you with specificity what it is I want to extract from the ballot box for Siani. What it is I want you to open and find in the ballot box for Getibori 1 and 2. Or what it is I want you to find in the ballot box for Gekuyari, just to give you some examples. Instead, what they have done, my Lord, is to create a scenario rotating around suspicion with the hope that the court will be persuaded by the suspicion so created to go and open the ballot boxes from wherein they might find some evidence. My Lord, this is the highest level of a fishing expedition exercise. My Lord, if even from the evidence and the pleadings, you will note that there is nowhere where the count, the total count of the result is in question. Whether from the evidence or the pleadings, my Lord will find harmony in the results transmitted from the 134 polling stations to the tallying center, where they have been reduced into the form number 35B. There is harmony. There is no discrepancy which has been shown that results from a particular polling station recorded in form number 35A are not the results which have been captured in form number 35B, the tally sheet, if I may use that word, my Lord. There has been no evidence, it has not been demonstrated whether by evidence, my Lord, or even from the pleadings, that the results in the forms 35A and 35B are different from the results in the Kim's kit. We have not been shown the conflict, my Lord, in those results. Instead, my Lord, what we have been taken through, whether from the pleadings or evidence, is that there is this physical voters register which was unveiled to the voters on the voting day, and therefore they did not interact with it. They did not see the cancellation of their names on that voters register, and therefore the voters register was non-existent, and that therefore you should open the ballot boxes to find whether the voters register indeed existed.
I think there is no order, there is no prayer for voters register in what we are listed.
No, let him submit.
So
You have your rebuttal.
Okay, my Lord, I'm well guided.
Let him submit.
My Lord, I am saying that that grain of evidence that because the voters did not interact with the physical voters register, that it was there, and refusal to appreciate existing precedents which have been set by the superior courts. My Lord, evidence was lent by the first to the third respondents through cross-examination and through the evidence in chief coming from the first to the third respondents, that the only time when the physical voters register becomes necessary under our prevailing legal dispensation is where the biometric identification via the KIMS fails. The evidence, whether from the petitioner and his witnesses or from the first to the third respondents, is that there is not a single instance where the biometric voter identification totally failed so as to require the reversion into the complementary mechanism of the physical voters register. Further, my Lord, and as was confirmed by petitioner's witness number 3, one Joy Gaki, and which is reiterated in the evidence of the witnesses for the first to the third respondent, the KIMS kit, which is the document which is used for identification, my Lord, could not start without scanning a QR code which is domiciled in the physical register. The KIMS kit could not start, my Lord, minus the physical register, in other words. And indeed, it was extracted by the petitioner's advocates in cross-examination today from one of my witnesses, my Lord, that register was not even being opened. It was being scanned when it is still sealed in a transparent envelope. It was not even opened. It would be scanned there when it is intact, and then the KIMS kit would start. So then, my Lord, if this is the case, what are we opening the ballot boxes for in search of the register? What are we opening the ballot boxes for in search of the register when it has been proved that no KIMS kit could have started without the physical register, when it has been proved my Lord, that register is intact. Nobody claims to have seen it opened anywhere. That question of the register, my Lord, irrespective of one individual known as Collins Munene, who is alleged to have been registered for a polling station known as Mwandu, has been very well explained by the witnesses for the first to third respondents as having been a stray registration, my Lord, during the ongoing nationwide voter registration, which was ongoing even in the lead up to the by-election of 27th of November last year. It has been shown, my Lord, by my witnesses, that this stray voter was in any event flagged by the system, so that even had he turned up at Mwandu polling station to vote, he could not have voted anyway. And the evidence of the petitioner and his witnesses confirms that no one saw Collins Munene at Mwandu polling station that day. And Collins Munene himself has not been called as a witness before you to confirm that he voted at that polling station that day. My Lord, other than that one stray registration of Collins Munene, the petitioner has not shown you any other registration following the freezing of the register as at the lead up to the 2022 polls to justify the allegation that the voters' register was tampered with. My Lord, the first respondent has been forthright. The polling station concerned, evidence has been lent to show there is a single discrepancy in the numbers. There is 399 voters in the register, the physical register, and there are 400 voters in the register in the KIMS. My Lord, this speaks to the evidence of the stray registration. There has not been shown any other single discrepancy in this regard. The petitioner has not demonstrated a pattern by the first to third respondents to interfere with the voters' register with a view of attaining a skewed outcome in favor of any of the contestants. My Lord, on the same physical voters register which I indicated that the voters physical register would only come in at the tail end where the KIMS have failed, permit me to rely on the NASA case. It's popularly known as the NASA case, the full citation being NASA NASA versus the IBC, Civil Appeal number 258 of 2017. My Lord, the thrust of that authority is the KIMS is the primary document of identification. The KIMS is the primary document of identification. And my Lord will recall that the reason why Kenya went for electronic identification is informed by past incidents, historical past incidents, my Lord, which have even led to generation of reports, including the Kriegler report and others, to the effect that technology has more security features than the physical form. Technology has more security features than the physical form. That's why it is preferred. My Lord, touching on the same question of scrutiny, but in a general manner, scrutiny and recount, the petitions who had been lined up to testify have not testified. And it is from those witnesses, the petitioner and the chief agent draws evidence in respect to certain polling stations. So, my Lord, I'm submitting globally that in every which witness has not been called, that particular polling station allegation is unsupported by evidence and must be struck out from consideration for the purposes of scrutiny. Because, my Lord, scrutiny does not operate or is not guided by hearsay evidence or suspicion. My Lord, let me go to the polling station. The polling station itself, my Lord, remains the primary and the final arena of contest for the results between the parties, as was confirmed, my Lord, in the seminal case of Maina Kiai and the 5 others versus the IMBC and 2 others, 2017 EKLR. My Lord, by dint of that judicial authority, we moved from where the returning officer was the main player in the election, where he could tamper with the results, where he could correct the results from the polling stations as he receives the results from the presiding officers. In a manner of speaking, the returning officer became a team leader, So, my Lord, no matter what ammunition my learned friend Mr. Dawanjiru is going to put on the RO, in so long as he has not impugned the evidence from the polling stations, he is aiming his missiles, my Lord, to the wrong party. My Lord, it is at the polling station where the candidates and their agents have as of right the remedy known as recount. They are supposed to demand this remedy called recount from the presiding officer in the first instance. In all the 134 polling stations, my Lord, and from the evidence emanating from the petitioner's witnesses and the first to the respondents' witnesses, not a single recount was sought. Not a single recount was sought. Not a single recount was therefore denied. My Lord, the forms that the 5A, which are, if I may use this one, declaration of results at the polling stations, have been witnessed by the agents who are present at the counting. There is provision in that form 5A, for an agent to refuse to sign with reason. It is put into bracket with reason. To refuse to sign the result with reason. Again, this is yet another remedy, my Lord, which has not been exercised in a single polling station of the 134. There is no agent who has refused to sign with reason and indicate reason. The alleged alterations, my Lord, from 135A, my learned friend, Mr. Kirago Wadhuta, for the petitioner, has taken you through several pages of the results in what he purports to be alteration of results or alteration of numbers, my Lord. My Lord, I understand alteration to mean either a cancellation, or a change of the number. So that if it was number 1, it becomes number 2. If it was 10, it becomes 100, or it becomes 20. I do not understand alteration to mean an emphasis on the number, so that if 1 is written as 1 and the pen has been repeated on 1, my lord, to me that is an overemphasis or an overwriting, an overemphasis on the number, and it is not an alteration. In any event, my lord, when my witnesses were here, the first to the third respondents, my learned friends for the petitioner did not take them through the pages you have been shown. They were taken through, I believe, a maximum of 3 to 4 pages. So for my learned friend now to come and give you a count of polling stations in excess of 10 moving upwards, my lord, it is the council giving evidence from the bar. It was the council giving evidence from the bar, and all those additional stations he has mentioned, my lord, will stand disregarded. My lord, I move to an alleged breach of custody of the election materials. And a lot of emphasis was laid on a polling station known as Getibori 1 and 2. And the video evidence was played to this honorable court regarding that polling station. My lord, number 1, starting from the video evidence which was shown, there is not a single clip which shows the IMBC team parting with the election materials. We did not see a non-IMBC person carrying the ballot box. From the evidence, whether from the petitioner or from the first to third respondents, the cause of the fire at Getibori 2 is accidental falling of the gas lamp, which exploded. From the evidence of the first to third respondents, that explosion caused panic and commotion and attracted people in the neighborhood who rushed into the polling station. And my lord, even from the video clips, we can hear what those people are saying, or rather you may be able to make sense of what those people are saying. And you will note that they are coming to the polling station to find out if the votes are being burnt. They are not coming to the polling station to check vote stuffing. My lord, in the same evidence, from the video and from first to third respondents, witnesses, there is nowhere where the CS Roko takes charge of the polling station. There is nowhere. There is nowhere where the PO of Getibori 1 or 2 is answering to the command of the CS Roko. And that the delayed count has been, for both the stations, has been explained to have been caused by that fire explosion, which was contained, my lord, duly documented in the polling station diary, the PSD, and reported to the police. In fact, the presiding officer who testified on this station 2, Getibori 2 of 2, indicates to have done 3 reports regarding this matter, underpinning the seriousness with which the IMBC takes this kind of incidents, my lord. It was proved that the aperture from both boxes, Getibori 1 and 2, had been sealed by the time of the fire outbreak. That both ballot boxes for the 2 polling stations were safely secured in a motor vehicle and were guarded by the police in the polling station. That there were no third parties who gained access to the materials during this episode. That at the resumed counting of the ballots, my lord, from the evidence, the counting could only be done in one room, polling station 1, for health reasons, my lord, following the fire outbreak and the ensuing suit. That, my lord, during that counting, the ballots for stream 1 were counted separately from the evidence, and those of stream 2 were counted separately. That results from both polling stations are witnessed by the agents present. My lord, there is evidence that there is an agent who witnessed the results in both stations, on behalf of the petitioner. And that the witness, my lord, denies that he was an agent for the purposes of this election. My lord, will look at the evidence of that witness and will note that in the entire evidence he is trying to run away from being an agent, and he terminates his evidence in chief by saying that when he went home after the counting, he was called by the other agents from the polling station, and they were asking him, "Why have you gone home? How will you be paid now? How will you be paid?" Then he answers them according to his evidence, "I don't need to be paid because I'm not an agent." My lord, the PO, the presiding officer for Getibori 1, Lendia Kamau, indicated that when she moved into Getibori 1 with the ballot box for the counting, she found the counting for Getibori 1 going on. And she found this petitioner's witness who is trying to run away from being called an agent. I believe he is called Simon K. Namu. If she found him seated there, witnessing the result, the count for Getibori 1. And that when Getibori 1 finished their count, Getibori 2 also counted in the same room. And that those present in the room remained therein, including this person called Simon Namu, who is running away from being an agent, and that he never signed. And that when Getibori 2 also counted, the witnesses, the agents present were invited to sign. And that is how Simon ended up signing for Getibori 2 as well, according from the evidence of Lendia Kamau. My Lord, the requirement of law is the agents present after the counting sign. It's never a requirement. It's never a specific requirement that the agents for which polling station, it is just says agents present sign the results. The agents present sign or witness the results. So in as long as an agent has one way or another found themselves into the counting room, there is no illegality or irregularity for that witness signing the results. My Lord, if you interrogate the polling station diary and the results, let me go to the results, my Lord, not the PSD, the results from that 5A for Getibori 1 and 2, you will find this agent for the Democratic Party has put his identity card number. He has put his identity card number. You'll also find his mobile telephone number in Getibori 1 and a signature and date. This is replicated in Getibori number 2, and all these numbers tally. Complete harmony, my Lord. No evidence was lent by the petitioner to show how the first to third respondents could have obtained the ID number for the DP agent and his mobile phone and if the allegation by the petitioner is that there was forgery, my Lord, there was forgery of this witness's signature, the same, my Lord, amounts to a criminal offense if the allegation, and I understand that to be the petitioner's allegation, that Simon Namo's signature was forged so that he was made an agent for the Democratic Party in Getibori, that is an offense, my Lord. If it be an offense, my Lord, the standard expected to prove that offense becomes the one beyond reasonable doubt. We jump from the intermediate standard, my Lord, and we go to the one of beyond reasonable doubt, which we respectively submit was never met. There is no evidence of this incident having been booked with the competent authorities to investigate the alleged forgery of his signature. There is no evidence that these signatures were ever subjected to an handwriting expert, and such report availed. So that therefore, my Lord, even if this matter were taken before the criminal court, any person charged with such an offense would merely walk home because the standard was never met. Now, my Lord, in that Getibori, because a lot has been said about it, no recount was sought, both Getibori 1 and 2. No agent refused to sign with reason. My Lord, from the evidence of the petitioner's witness PW2, the chief agent, PW2, agents were permitted to photograph the results in the 134 polling stations, all the agents and the leeway to photograph the Form 35A. And in fact, he confirmed that that was done. My Lord, the purpose of the grant of this leeway is to enable the parties to verify the results. The expectation would have been that the chief agent is collecting these results from the agents in the polling stations and verifying them vis-a-vis the results which are being submitted to the returning officer at the tallying center. My Lord, he confirmed, PW2, that he was sent those images, that he was sitting at the tallying center, that the results as they come in at the tallying center, as they are being received by the returning officer, are projected on a screen. And this is also the evidence of RW01. Those results are cast on a screen. So that as the returning officer is populating form number 35B, everybody is seeing what it is he is keying in. You are able to see as a diligent agent, and from the images of the Form 35A which have been sent by the agents from the various polling stations, are the results which the returning officer is populating into the Form 35B, the correct ones. My Lord, this witness, when I put this question to him, he told me, or he told you rather, my Lord, that he did not verify a single result. Yes, I was there, but I did not verify the results. The question, my Lord, then becomes, when you are seeking to open the ballot boxes to look for the Form 35A, what is it are you going to look for there? Other than the hope that you will stumble into something that the IMBC may have done wrong, which amounts to a fishing expedition, my Lord. Alleged bribery, my Lord.
How is the time? 2 minutes.
Yes, let me wrap up. Alleged bribery, my Lord.
Yes.
Bribery. My Lord. Evidence shows, number one, those allegations related to incidents outside the polling station. Number two, my Lord, bribery is an election offense. The standard of proof, my Lord, beyond reasonable doubt, it has jumped beyond, it's above the intermediate standard. The expectation, my Lord, hard evidence. Where is the report of the bribery? Where is the report of the bribe? Who is the bribe giver? Who is the bribe taker? My Lord, what action taken to date? By the time of you are hearing this evidence, what action taken? And even assuming there was bribery, my Lord, as alleged, it has not been linked to what is in the ballot boxes. The nexus is missing. We have not been shown that because of that bribery, there was an interference with the results, whether the results as counted and recorded in the forms and the results in the ballot boxes. So that allegation does not support any prayer for scrutiny recount. Commotion and violence, my Lord, again, in like manner, my Lord, evidence places those allegations outside the polling station. Finally, my lord, finally. Costs follow the event. I rest by citing to you, my lord, the authority in Haraf Traders Limited versus Narok County Government.
Sorry?
My lord, I'm submitting that the petition having sought recount and scrutiny must be prepared to bear the costs of this application if it is dismissed.
There was a case you were citing, that's what I wanted.
Yes, I'm saying costs follow the event.
The case?
Costs for the application.
Yes.
Yes. We are on
What
the scrutiny.
authority did you cite?
Sorry, my lord. Yes, I'm citing to you the authority in Haraf, Harf, Haraf Traders versus Narok County Government, 2022 EKLR.
2022 EKLR.
Yes, my lord. I rest, my lord.
My lord, perhaps before for the respondent rises to address you, my lord, I would seek your guidance as to their participation in this application. The fourth respondents.
They are participating. I just track out the affidavits.
Thank you, my lord.
My lord, I had perhaps thought that may I finish, Mr. Kashuba, my
The
address?
judge has already answered you, so you allow me to go.
Why would they not participate?
No, my lord,
They are a party sued.
that is true, my lord.
Mr.
The reason,
Ndegwa, please allow me
the
to
reason
submit.
why I thought they should not participate, and Mr. Kashuba, you know the rules when an advocate is addressing, is that, my lord,
Just sit down, let's hear what this is.
that, my lord, whatever we are addressing you on is premised on the evidence that was recorded or that came before you, my lord.
Yeah.
As it is today, my lord, they do not have evidence insofar as the affidavit is in issue that can controvert their application. As it is, my lord. Would it therefore perhaps be possible for them to address you while they do not have or they have not controverted our evidence?
You mean they didn't file a response?
They did.
Please.
Okay.
Thank you.
Thank you, my lord. My lord, the fourth, on behalf of the fourth respondent, my name is Gachuba. The fourth respondent, my lord, opposes the application dated 22nd December 2025. We did file a replying affidavit, my lord, and written submissions dated 28th of January 2026.
Now, I should have told you you are 30 minutes.
Yes, my lord. My lord, very briefly, the burden of proof is on the petitioner in this case. To prove, my lord, the allegations or the grounds upon which this application is based. And my lord, we rely on section 107 or 107 of the Evidence Act, as explained by the Supreme Court in the case of Odinga and 5 others, as the IBC reported in 2013 as KESC 6, my lord.
Sorry, 2014.
2014, my lord. 2013.
Is it 13 or 14?
2013.
That's the first one.
KESC 6 KLR, my lord. That's the first.
Okay.
The first Odinga case. And my lord, the Supreme Court stated as follows, if you permit me, that a petitioner should be under obligation to discharge the initial burden of proof before the respondents are invited to bear the evidential burden. My lord, we tie that submission with Rule 29, paragraph 2, which required the petitioner, my lord, to show you sufficient reason for this application, or for Rule 29, sub Rule 2, my lord, of the Elections Parliamentary and County Elections Petitions Rules of 2017, which required the petitioner to demonstrate to you sufficient reasons for the grant of the order of scrutiny or recount of the votes. My Lord, that was expounded by your brother, Justice Odunga, in the case of Gideon Mwangangi Wambua and another, was as IBC and two others, reported in 2013 as KEHC 2392, KLR, my Lord, and
KEHC?
KEHC 2392, bracket KLR. At paragraph 26, my Lord, is a relevant paragraph where your brother Justice Odunga says that, as indicated above, the aim of conducting scrutiny and recount is not to enable the court unearth new evidence on the basis of which the petition would be sustained. I don't want to read the rest, my Lord, it's a long one. My Lord, we have not seen any evidence that has been adduced by the petitioner to justify recount and scrutiny of the votes. And my Lord, I'll refer you to the case of Munya versus Kidinji and two others, reported in 2014 as KESC 38 KLR. My Lord, I'll refer you to the relevant paragraph, that is 153D, where the Supreme Court, my Lord, stated that where a party makes a request for scrutiny or recount of votes, such scrutiny or recount, if granted, is to be conducted in specific polling stations in respect of which the results are disputed, or where the validity of the vote is called into question, my Lord. My Lord, there is no evidence before you that the petitioner questioned the results in any of the polling stations that they have listed in prayer number 3, prayer number 6, prayer number 8, my Lord. And my Lord, looking at regulation, rule 29, sub-rule 4D of the Election Petitions Regulations 2017, my Lord, one of the documents, my Lord.
24D.
Yes, 29, sub-rule 4D.
4D.
Yes, my Lord. One of the documents, my Lord, that is to be scrutinized when you open the ballot boxes are the written complaints of the candidates and their representatives, my Lord. That is one of the documents to be scrutinized. And my Lord, it is on the evidence of the petitioner that they did not write a single complaint in any of those polling stations, my Lord. So, my Lord, there is no sufficient reason why you should open those boxes for scrutiny, because even they did not provide any complaint that you will be scrutinizing, my Lord. My Lord, I see at paragraph at paragraph 4, my Lord, the petitioner is asking you that you allow him to get full and unfettered access to KIMS. My Lord, that's not a prayer for scrutiny. And we pray that you disallow that prayer, my Lord. And in any event, my Lord, it's not one of the documents that the law allows scrutiny, my Lord, under Rule 29, Sub-Rule 4. That rule, my lord, does not include Kim's logs. So, my lord, we pray on the strength, on the authority of Munya and Kirinji once again, my lord, at paragraph 164, where the Supreme Court stated that otherwise, why should a court order for scrutiny in a polling station in which there is no dispute whatsoever? My lord, if you look at paragraph 3, for instance, as well as paragraph 6, 3 and 6, my lord, you'll see quite a number of polling stations where we did not see any evidence led by the petitioner. So the Supreme Court then goes on to ask, my lord, what would the court be scrutinizing? It is clear that the overwhelming trend in the emerging judicial opinion frowns upon the possibility of granting orders of scrutiny that serve no purpose and that may indeed be contrary to the public interest. My lord, at paragraph 3
Of what?
of the, I mean prayer 3, my lord,
Prayer 3.
of this motion, we did not see any evidence on Kianamo polling station, my lord. There was no evidence that was tendered in respect of Chicago Social Hall. There was no evidence in respect of Ivutoka Primary School. There was no evidence in respect of Career Primary, my lord. That's Career Primary 2. There was no evidence, my lord, on Kamogo Primary 1. There was no evidence on Karambari Primary, my lord. Karambari. And there was no evidence, my lord, on Mbeere Primary 1 and 2. That's on prayer number 3, my lord. On prayer 6, my lord, we did not hear any evidence on Chicago Primary School. We did not hear any evidence on Siangera Primary School.
Which was the second one?
Siangera.
Siangera.
There was no evidence on Kavashi Primary School.
Kangwashi.
Kavashi. Kabashi. My lord, there was no evidence on Kune Primary School. No evidence was brought here by any witness in respect of St. Peter's Primary School. There was no evidence on Kageri Primary School. There was no evidence that was brought to this court on Marango Primary School. There was no evidence on Kenire Primary School, my lord. Kenire. I'm pronouncing it the way it's supposed to be. There was no evidence, my lord, on Karuari Primary School. There was no evidence on Baraga Primary School. And there was no evidence on Kiadambo Primary School, my lord. So, my lord, then the question is, what would the court be looking for if it allowed scrutiny in some of those stations, my lord? I'll leave it at that, my lord. My colleague will take it off.
Yes.
So, my lord, Adrian for the fourth respondent. Further to the submissions that have been made, it is important to highlight at this point that there is well settled jurisprudence as to how election outcomes ought to be treated, and courts have been emphatic on different occasions that not every allegation of irregularity would lead to nullification. Courts have gone
Are we
further.
talking about nullification at this point?
Yes,
or
I'm
scrutiny?
just pointing out in passing
Okay.
nullification, because that's eventually that's what they are seeking. Because they are seeking material now towards that. Those are the final release that they are seeking. So the superior courts have systematically been clear that proceedings in the nature of election petitions have to be governed by clear evidentiary thresholds, the so-called intermediary standard, not beyond reasonable doubt, but at least above the balance of probabilities. So basically, not every irregularity would lead to the invalidation of an election. Now, the Supreme Court in various decisions that have been cited, including the various Raila Odinga petitions, have laid down the principles on scrutiny and recount, such that there is a threshold to be met before such a relief can be granted. First, and this is borrowing from Munya, scrutiny must be justified by credible evidence of irregularities. Hence, in this case, the petitioner bears the burden of a dual nature to prove that there are some irregularities that occurred and that those irregularities have some impact on the outcome. There was an effort to do that via the petitioner's affidavit through a summary that was presented at their paragraph 114 of the petitioner's affidavit, where the petitioner himself, when appeared for his evidence in chief and cross-examination, confirmed that the total effect of the votes, assuming that his allegations were to be proved, would amount to 469 votes. When accorded a chance to indicate whether that would alter the outcome, the petition did confirm that the 469 votes, assuming that they were just freely given, would not even have altered the outcome. Now, the application before you, my lord, seeks some drastic reliefs in the nature of scrutiny and recount, which we maintain are speculative in nature, given that they are not supported by any evidence adduced by the petitioner. The only evidence available before this Honorable Court is that tendered by witnesses PW1 to PW11. PW1, as I've highlighted, has indicated that there would be no significant change in outcome, even if all his allegations were to be accepted hook, line, and sinker. Petition 2, PW2 claimed to be a chief agent, which on examination was proven to be a fraudulent claim. So as such, the evidence of PW2 cannot be relied upon to make any determination. PW2 also went on record that he never witnessed anything. So there was no evidence of a probative nature that emanated from PW2. There was then PW. Okay, I'll just move to PW8. They are not in any particular order. PW8 is another witness who claimed to have been shot at Kaungu, but on examination, he couldn't offer valid evidence of that claim, having claimed that he was first rushed to Mbeere District Hospital, and equally claiming to have been rushed to Chicago Police Station, for which no OB was provided. Having claimed to have gone to Chicago to seek a P3, which was a necessity before he could be treated, but which he never obtained. And having claimed to have been referred to a different hospital when the records indicate that he had been discharged. There was PW11, who on her part claimed to have been engaged on a bribery affair with allegedly one Jagagwa Murioki, and with no indication whatsoever as to whether she ever voted or where she voted. There was PW3, her fundamental claim was that she was left out of the recruitment as a PO, but who indeed affirmed that notwithstanding her absence, the process went unhindered. There was PW10 who again claimed to have witnessed bribery. But initially indicated that she declined to receive the bribery items, but then eventually said that she accepted them in bulk. So there was Peter Jerungare, we have talked about him, that was PW2. And there was PW5, Sisri Murugi Jage, who claimed to have voted at Gekuyare, notwithstanding the fact that she was not a registered voter. So basically, those were the only polling stations whose evidence was adduced to court. And the evidence was proved to be lacking in credibility, full of falsehoods and fabrications. And for this, we shall invoke the doctrine, forces in uno, forces in all. Meaning that this is evidence that the court cannot utilize because it has falsehoods that run across. So in which case now it will be very difficult for this honorable court to grant any relief based on hollow evidence, fraudulent claims, and material that have no probative nature. I pause at that point so that my learned colleague can proceed.
Ms. Rose Mbeere for the fourth respondent. My Lord, I do associate with the submissions of my colleagues, save to add the question for determination, my Lord, before this court is whether the petitioners have established or demonstrated sufficient reason to warrant an order of scrutiny under the Rule 29 of the Elections, Parliamentary and County Elections Petition Rules of 2017. In addition to the case law already provided by my colleagues, I will rely on the case of Nathif Jama Adama versus Abdi Kaim Osman Mohammed, 2014, sorry, my Lord, EKLR, where the Supreme Court held that in determining and considering an issue whether to grant scrutiny, whether the polling stations, in the polling station, there was a dispute as to the election results. My Lord, it will be noted that in all polling stations that have been pinpointed by the petitioners, there was no dispute as to the allegations. Further, my Lord, the witnesses in the respective polling stations adduced evidence and confirmed that indeed they did not file any objection and they in fact executed the Form 35A. the allegations remain unsubstantiated and is to bribery and violence. My Lord, I refer you to section 82, where there is contemplation of what votes the court is supposed to look into when such order is granted. There were no allegations that such votes existed. And my Lord, for that reason, we will be praying that the order of scrutiny be dismissed with costs.
My Lord, to summarize on behalf of the fourth respondent, my Lord, the purpose of scrutiny and recount is to identify void votes. That is the simple purpose of scrutiny and recount. My Lord, for that submission, we rely on section 82, subsection 2 of the Elections Act 2011, which lays 6 grounds, my Lord, on which or circumstances that would void votes, my Lord. My Lord, because of time, we believe that you'll be able to read section 82, subsection 2, which is the anchor of our submission. Thank you, my Lord, for your time, and we pray that you dismiss the application with costs to the fourth respondent.
Rebuttal?
Yes, my lord.
Rebuttal, you have 20 minutes.
My lord, we begin by indicating that it's unfortunate
This is Mbeere.
that the respondents have all misconceived our
You didn't say
application.
your name.
My lord, my name is Dewanjiru. My lord, it's unfortunate that this evening the respondents have chosen to misconceive our application, which misconception has invited them to overshoot the runway in what is famously known in aviation as runway excursion. They have overshot, my lord, because they have invited you to apply a standard of proof that is not applicable in such an application. In such an application, my lord, the petitioner is merely expected to lay basis in what in civil cases is known as prima facie case. A prima facie case, my lord, is laid down when evidence has been tendered. The standard of proof being suggested, that is of the standard of proof of balance of probability, is only applicable at the tail end of the petition. To the best of my knowledge, my lord, and just to prove how misconceived they have highlighted issues of bribery and violence as what you ought to consider in granting this application. Even if we were to open the ballot boxes, my lord, even if we were to scrutinize the documents, other than where it is indicated, my lord, as it was proved, my lord, you will not find corruption in it. You can only believe the witness who appeared before you, who said that bribery was initiated at the behest of the fourth respondent, who chose not to invite witnesses who were pinpointed by the witnesses, the petitioner witnesses. They wasted their opportunity to rebut that proposition and that allegation. and submissions from the bar, my lord, cannot remedy and or fill that gap. Further to that, my lord, the question of the application of Section 82, where Mr. Kasuba speaks about void votes, was expanded in the case of Raila Odinga versus Uhuru Kenyatta, Supreme Court in 2017, where the Supreme Court indicated that it's not just the numerical aspect of scrutiny that we are looking at. The Supreme Court in that case indicated that election is a process and is a legal process. So therefore, my lord, granting the orders of scrutiny will assist the court to confirm whether or not there was compliance with that process. Remember, my lord, Section 83 of the Election Act provides circumstances under which an election can be voided on the basis of non-compliance with the law.
Sorry?
Section 83 of the Elections Act provides circumstances that an election can be voided on the basis of non-compliance with the law. Where the law says do not bribe, and most importantly, Article 81, evidence is led, evidence is uncontroverted, and it goes on record that indeed it took place. At the fullness of time, we'll be invoking the import of Section 83. So to say that we are only looking for the lawful votes or the unlawful votes domiciled in the ballot boxes, my lord, will be failing to appreciate the import created by the case of Raila Odinga versus Uhuru Kenyatta, Supreme Court 2017. Further to that, my lord, you have been invited by Mr. Mongela to find that even in polling stations that there were agents, but agency, the principle of agency or the infrastructure of agency in an election is meant to cement the principle of transparency, accountability, verifiability, the fairness and the freeness of the elections in universal suffrage. Where witnesses have appeared before you, my lord, for example, in Mbeere polling station, and Simon comes and tells you, my lord, I was not an agent. The only thing that could have disapproved that preposition, my lord, is the fourth respondent bringing an agent who was present in that particular polling station to say, yes, I saw Simon. I was with Simon. In Mbeere, my lord, when witnesses say that ballot boxes were handled by Raya, and it was not in the custody and control of the election body, to controvert that evidence, the fourth respondent was to come with his agent and say, no, I was present, I saw the engagement and the involvement of the electoral body in that process. When we say that agents were not in the motor vehicle where these boxes were dumped, and that they were not in control of the Electoral Commission, the converse would be that the fourth respondent again invites his witness who was an agent who would come and say, I was with those boxes in that particular motor vehicle. So if the infrastructure of the agency infrastructure in an election has been compromised, how else can we be able to determine the fairness the security of that elections, the accountability, the transparency of that elections, if a nod of scrutiny is not granted. My Lord, you recall that two presiding officers from Getibori.
My Lord, in a rebuttal, are we expected to hear matters of fact or matters of law in this rebuttal? Because we are.
I think they can countermand, contradict matters of fact. Because you pose a matter of fact.
In an application, my Lord. This is an application.
Yes, they made the application.
Yes.
Or are you saying that they did not raise those matters of fact in the application?
Yes, they did raise, but I'm saying this is a rebuttal. He's not prosecuting the application.
No, he's not.
Yes.
So you are saying he's going beyond the remit?
Yes, my Lord.
Okay.
Yes, yes.
Yeah, maybe I could agree with that, particularly with regard to this question of the agency.
I'll just address you on one more issue, and then I invite my learned friends. Well, you have been told that Collins was a stray registration. They choose to consider such a grievous issue that affects the integrity of the voters' register, the security of the voters' register, the verifiability of that register, and the transparency of that register as a mere stray. That's how casual they have decided to be. Yet, the foundation of an election, my Lord, is on the basis of voters' register. If a voters' register, my Lord, could have stray registrations, then how can the universal suffrage yield a free, fair, secure, and verifiable elections? This stray registration, my Lord, itself compromises the principles under Article 81 of the Constitution. And to that extent, my Lord, that there is a violation of that particular provision, my Lord, it is justifiable that the order sought be granted. Allow me to invite my learned friend, Mr. George, to proceed from where I've left.
Thank you, my Lord. Karudhi for the petitioner. My Lord, I wish to address you on one issue, and that is with regard to the issue of alterations to the register, and generally the issues that IEBC, or rather the way the IEBC has tried to explain the shortcomings in this petition. And my Lord, you are being led to believe...
You're talking about alterations to the register or to the...
To the documentation. We have raised it as a general ground, then we have narrowed down. If you recall the overwritings. So such that, my Lord, generally...
So it's the register and forms 35?
Yes. Generally, my Lord, irregularities will tend to revolve around errors, administrative mistakes, and such other alterations. And my Lord, multiple cancellations, alterations, and overwritings, where they are not countersigned or stamped, that is, they are not properly authenticated, as innocent as they may seem, will amount to serious breaches of the electoral process. My Lord, there is no duty on the electoral staff or electoral personnel to overwrite or to correct any documentation, even as innocent as it's being made to sound. And my Lord, when we led the witness with the returning officer with regard to that overwriting, it's important for the court to note that it all related to to the petitioner and the fourth respondent. And the only way of the petitioner to identify the effect and the impact of those alterations would be by looking at the original documentation as it was stored by the IEBC. In closing, my Lord, the margin of 494 votes between the petitioner and the fourth respondent, with 4,606 affected votes, and with 37 stations having alterations, and coupled with an admitted failure in explanation of such alterations, puts up a strong case for scrutiny. And at this point, we wish to refer you to the case of Abdullahi Muhammad versus Mohammed Abdi. That's election petition number 14 of 2017, paragraph 63 to 64, and that is where IBC fails to produce satisfactory information, then the court should should consistently draw adverse inferences.
This authority is what?
Um,
Abdullahi Muhammad
versus Mohammed Abdi. That's election petition number 14 of 2017.
Was this brought up, my lord, earlier? It is being brought up now.
The authority is brought up now, but they're talking about the, if I understand him correctly,
Yes.
is the disparity in votes, the small number of votes in disparity. This is what you're talking about?
Yes.
Okay.
And my lord, in closing, Mr. Mongela stated that our request, or the request by the petitioner, is wide and non-specific. My lord, to the contrary, the request is narrowly tailored. We have listed the number of stations where, or the number of documents, specific documents that need scrutiny. But my lord, in final submission, the first respondent cannot simultaneously admit that it failed to provide the physical register and then deny the petitioner access to the only remaining record of knowing how voters were identified. And that would be the KIMS log, and that is the data that will guide us to know exactly what happened. And that, my lord, we pray that it should be revealed to the petitioners.
Is there time?
Just 3 minutes.
3 minutes.
Yeah, my lord, I do not want to, Kiragwa Duta, to overemphasize on that issue of the narrow margin, my lord, has already been addressed, but you'll also find it in the case of Hassan Mohammed Hassan versus Abdul Karim Nuno Amin
Versus?
Abdul Karim Nuno Amin. Nuno is N-U-N-O-W. It's on EKLR, is a petition number 6 of 2013. The paragraphs are not numbered, but the court finds that where states, citing Joho versus Nyange, states that where the margin is very narrow, justice will be done and be seen to be done if a scrutiny should be ordered without laying a foundation, simply to expeditiously dispose the petition and save time, which would otherwise have been spent on full hearing. So there's even no need to lay a basis when the margin is very narrow. That is a finding in Joho versus Nyange and cited.
Is that Supreme Court?
This was
I think it's a High Court case.
this was at the High Court level. But then, my lord, you would find that reflected in Raila 2017.
Sorry?
You'll find that position. You'll find that position, my lord, is actually a reflection of the Supreme Court's decision in Raila 2013, where the court at paragraph 49, and this is in the ruling on the scrutiny application, paragraph 49, the court actually ordered scrutiny of all election materials.
What did the court say?
The court said, further, we note that the court in Raila 2013, this is 2017, ordered a scrutiny of the following forms. So all the forms in that election across the country. And what the court said, in making these orders, the Supreme Court elaborated the scrutiny would serve the following aims. And there are three. Establishing the accuracy or otherwise of the total tallies of the presidential votes as indicated in Form 34s. That's what we are seeking here. Establishing the number of registered voters, the number of valid votes cast, and the number of rejected votes as indicated in each form. My lord, that's what we are asking. Finally, comparing the number of registered voters indicated in Form 34 and the number of registered voters on the principal register. Principal register, the principal register to be used would be the external hard drive presented by IEBC in the annexure to the replying affidavit of Ahmed Isaac Hassan. So basically, we are saying, give us the number of registered voters according to KIMS. That's why we ask for the data in the KIMS. Then we look at the data in the Form 35s. Then we see, are they the same? Already, it has been admitted, they are at variance. So that we say, give us the logs from the KIMS. Then we have the register that was provided to us.
What was at variance?
Sorry, my lord?
What was at variance? You just said something was at variance.
We already, now in the present case,
Yeah.
we already have an admission that at least in one polling station,
Oh, that's one.
there was an addition, and then we have other polling stations which have not been explained. We have other people. We had witnesses who said they have been moved. So we have all that. And this is very important. Section 20, Mr. Kamala, it's the law, it's the law.
Because it's a point of fact. He has said that he had people, that there were people who were moved. Yes, it's only
okay.
one case.
We can leave that. We can leave that.
I think it's only one case that I'm aware of.
Yeah, it's only one
So
case.
far.
And I asked the court to take judicial notice that the petitioner has not relied on any of its witnesses. It's relying on witnesses of the defendant.
Mr. Kamatho, the court will use that. And my lord, if you look at section 29, subsection 5, and this is of the elections, non-actually rule.
The petitioner has exploited the time.
Okay, 1 minute.
Just 1 minute. Just 1 minute.
I said 1 minute.
Yeah.
Just finish
Yeah.
your sentence.
Yeah, my lord, in the elections, parliamentary and county elections petitions rules, rule 29, sub rule 5, the law says, for purpose, and this is about scrutiny, for purposes of sub rule 4, paragraph B, every returning officer shall, upon declaration of results, seal the printed copy of register of voters at the election in a tamper-proof envelope, and such envelope shall be stored by the commission subject to the elections court directions under rule 16. My lord, what we've been told that
I think it's all right.
very well.
I'll read
Allow-
that.
allow the
I'll
application.
read that in relation to the evidence that is available.
Very well, my lord.
Your Lordship, if you may allow me just 30 seconds.
No,
Very well.
thank you.
All the 1 minute I saw.
That's the one I gave him.
There were two different applications, my application and his application.
No. That's it. That's it. There's so much material you've given me. more than, and a lot of it is what we might call rubric. Sorry? No. No.
Litigation must come to an end.
No, let's agree now on what date I will issue the ruling. I think we can, let's say 26th. 26th, although I'll be at a conference, I think I have no choice. Because there's just no other time.
It's 9.
What are you looking at me for? It's a lot of homework.
My lord, that will be by email.
I think I will just upload it. I'll upload it, and if the scrutiny is allowed, scrutiny and recount are allowed, then there will be a whole host of rules. In my mind, I'm already settled on one aspect. Box 135 will be scrutinized. That one, there's no question for me. The rest is a question of seeing whether or not. But box 135, if I am unable to make my decision on anything else, on 26th, did I say 26th? Yes. On 26th, you'll get a ruling on box 135 with directions. But I hope I'll be able to say all that needs to be said in connection with the application.
And there is a high likelihood, my lord, that that is a smoking gun. Very high.
Okay. So there's that ruling, and then I think we for our record, we did say that if there's that, if the ruling, or in any respect, a report from the DR on scrutiny and recount would be on 17th of April. And then submissions, final submissions would be, what did we agree? We agreed on 22nd of April. I do not want submissions in respect of the DR's report, because you will have been involved in it. What I want from the DR's report is your observations, just observations. But for your final submissions now on the whole case will be on the 22nd of April. Are we together? One final thing is, yes.
My Lord, Kirago Aduta, we were just wondering whether maybe we can get some timelines on exchange of submissions so that we can know, we can work.
Let me give you those in the course of.
Very well.
Yeah.
Thank you. Thank you.
We'll send those out to you.
Thank you.
Although I have a good mind to make it simultaneous. but we'll see. Unless, is there anything else that I've left out?
My lord,
Yes.
probably before you close,
Yes.
just like the other time, on behalf of the bar,
My lord, we had made a request
Yes.
to get the type proceedings to the extent that they are available.
Yeah.
Possibly can guide us on the same.
You will. I can only promise that you might get them 7 days before the date of your submissions. I'm not even sure I can make that promise because the transcript right now has reached, was it 12th? The material we dealt with on the 12th is what we have received, and that is a raw. So it has not been certified by the DR. Because the transcript, the way it is being done, as I indicated from day one, and which has not worked as well as we anticipated, was that Nairobi would transcribe what they hear. And they actually have 3 teams that are doing it, but they are not doing it either fast enough or accurately enough. So I have now set up another scenario where the notes I told you will not be used as the official transcript are now also being typed by the secretary. So I'm making every effort to ensure that you have either the transcript or my notes. And I will see to it that you get one or the other. I can't promise you exactly when. Or shall I just dish them out as they come?
Yeah.
Like medicine.
The fourth respondent wouldn't mind receiving injections as they become available.
Becomes a bit
on available doses.
Becomes a bit untidy, but.
My lord, the other one is on curricula. I was again requested by the bar to ask for directions as to bears the cost for today, noting that tomorrow is Eid al-Fitr. The bar,
who bears
the cost for today's evening,
noting
that tomorrow is Eid al-Fitr,
and
they wanted a direction that Mr. Kashuba, being the most senior one, that the court does order. But Mr. Kashuba
The petitioner should, my lord. They brought us here.
Your Lordship, regarding the issue of transcripts, transcripts, I have a suggestion, and which we've done elsewhere, especially in arbitrations. As the script comes, and before it is proofread and a lot done on it, it can be put a watermark of draft, and not for use officially.
No, I would not allow that because it will create a lot of trouble. Yes. Because you'll be submitting now based on
the draft,
even erroneous material.
Very well.
Because the people who are transcribing in Nairobi are not legal people.
Okay.
They are what are they called? Madip is called. What's the name of Madip nowadays? Who is Madip by ICT? They are the people who are digitalizing all our documentation. So I have looked at them.
Yeah.
I would not issue the raw ones that I have seen.
It's okay. If they are far off, then...
That's why they have to be certified by the DR.
Very well.
Either they are certified or you get my proceedings.
Very well, my lord.
Yeah.
Thank you.
But I'll make every single effort.
Thank you.
And if I need to adjust anything, I'll adjust it in your interest.
Thank you.
Yes.
Thank you. You appreciate it.
Okay.
so noting that we've all finished, my lord, on behalf of the bar, we would like, and have been requested, to express our appreciation to you and to the court for the excellent hosting and management of the affairs throughout the hearing, including your staff. With Francis, the clock seemed to run differently. Maybe when we were speaking, it was moving a bit fast, but on a light note. But we feel very well handled, and we are grateful for how everything went. And even as council, our comfort, our interaction, as we moved on, improved. For example, towards the end, Kamotho was able to share a cup of tea with us. Well, in the beginning, he would even sit a distance from us. But my Lord, we are really grateful. Thank you so much from this end. Thank you.
Thank you very much. Again, like you said, I said last time, when a compliment is given, we receive it with gratitude and much appreciation, because we don't always get appreciated. Actually, I know once the judgment is read, once the judgment is read, at one team or the other, we will be saying all sorts of, they'll retract everything that has been said here.
But my Lord, these proceedings have been going live. And the comments we are also getting out there is that you are appearing before a very fair bench. Yes. That's the comment out there.
Okay.
And it has been actually been communicated to my friend that we have all received fair treatment before this court.
All right.
That at least can go on record.
Thank you.
The only part we have not received fairness again is on this part of the bar. They have refused to comply with the rules of seniority, my lord.
I know where you're going. And I know it's almost tea time. Let me say one thing about this particular case. I have actually enjoyed handling this case and the council who have appeared. Notwithstanding that it is a high stakes type of case because it is a political contest. There has been seriousness, there has been humor. I think in almost fair, equal measure. Council have sought throughout to exercise decorum, I think, and where it has not been exercised, maybe a small reminder has straightened us up. So you've presented yourselves as true professionals. I want you to get a lot of work, all of you. You have also been able to be dynamic in the sense that you have been able to adjust very effectively, or fairly effectively in some cases, to scenarios that you have not been used to in the past. For example, the time bank. And so we have all learned quite a number of lessons, I believe, including myself, because I think I had assumed that everybody knows how to do everything the way I've seen it done before. So this was a learning experience for me too. For the individual council, I have a little word for each one of them, which I've actually written. Mr. Karodoi, I assume that you are sort of like the leader on that side.
Yes, my lord.
I found that you are a man of order and attention. Asante. Thank you. Mr. Ndegwa.
Yes, my lord.
Passionate, incisive, full of humor. Mr. Wathuta. Dramatic. Somewhat overreaching. But very amiable.
Thank you.
Mr. Njiri.
Yes.
A man of insight and levity.
Thank you.
Mr. Kiroko.
Judge.
Forceful, emotional, but very apt.
I'm happy.
Respondent side, Mr. Mongela.
Yes, my lord.
This one, I couldn't find words other than calm and sober. Sobriety was what stood out.
Thank you, my lord. Thank you so much.
Mr. Kashuba. No, I found this sagacious is the word I could find, and insightful. Dr. Kamodho.
Yes, my lord.
A man of, this word is not used much even for me, but this is a word that says extrospection. That is not introspection, but extrospection and wit. Asante sana.
Thank you.
Mrs. Migwi.
Miss Migwi.
Miss Migwi.
Yes, Miss Migwi.
Okay, I got that wrong and I lose some 5 marks. Concise, composed. Asante sana. So I thought I'd better say those things because no one will say them to you, and I want you to be getting a lot of work from your clients. And I also request that if you don't mind, we take a picture because I have particularly enjoyed this case. So if you don't mind, we can go outside and we take a picture. I told you I had my gavel with me all along.
You never put it to use.
I did not put it to use because the purpose for which I would have put it to use would be to straighten someone out. But now I will put it to use to say that the proceedings have come to a close. Thank you. Dan, you lead us where we are going. We'll follow Dan. You show us.
We are coming.